Former State Senator John Keane, with help from Secretary of State Bob Evnen and Attorney General Mike Hilgers, believe tens of thousands of signatures required to get those initiatives on the ballot in the first place are invalid, citing fraud by the circulators and improper notarization. A lower court already disagreed. Nebraskans for Medical Marijuana saying in part today, quote, "People don't try this hard to destroy something that doesn't matter, and they cannot erase the 540,000 Nebraskans who stood with us."
The appellants only win this case by invalidating signatures, and they can only invalidate enough signatures to make a difference if the court adopts a false in one, false in all maxim that no other court in the country has adopted.
Attorneys for the state claiming because several hundred signatures were found to be fraudulent, something the petitioners didn't deny, then the credibility of those collecting signatures is shot.
Allowing the district court's opinion to stand would allow merely two bad actors to fraudulently place any measure on the ballot, so long as they both invoke the Fifth Amendment.
If the court rules in the state's favor, it could invalidate tens of thousands of signatures, putting the initiatives well below the constitutional threshold to be on the ballot and upending the work done to get medical marijuana in the hands of patients. And then Nebraskans for Medical Marijuana might again have to prove the already validated signatures are in fact valid. The state also saying if the small number of fraudulent signatures aren't enough to warrant a closer look, then likely, quote, "the public's confidence and the precious power of initiative may be shaken." Gutman argued to the court the petitioners can't do any better or any more than the state's election officials already have in verifying the signatures. The court is expected to make its decision in the next few weeks. Reporting in Lincoln, Darsha Dodge, 1011 News.